Hi, my name is Tom Dixon. I'm the host and founder of the Financial Experts Network webinar series. Our webinars feature true experts like elder law attorney Laurie Steiner, educating you on important financial or money topics such as, should you have a will? The answer is yes. In addition to that, Laurie will outline the 3 other documents that you really want to consider putting in place that include a power of attorney, a healthcare proxy, and a living will. Now, the replay is actually the highlights of a long webinar that Laurie did, and you can find the entire webinar replay on our website at financialexpertsnetwork.com, and you simply search under past webinars. I'll post that in the description field so you can find it. Now, if you're new to our channel, I encourage you to subscribe because this replay is one of many that we will post on a wide range of important, again, money or financial topics, and they all feature a true financial expert. So in addition to subscribing, I also encourage you to click on that bell to get notice when we do post new replays. And then if you like this replay, please click on that like button. And of course, if you have a question or a comment, please use the comment tab. So I hope you find this to be helpful, and I hope to see you back for future replays.
Today, we're talking about the necessary, essential estate planning documents and then probate avoidance. So let me see. There we go. So I'm starting first with the essential estate planning documents. What I call them is the core 4 documents. So we're going to go through each of these different documents that it's important for everybody. And here's the first question is, do only the rich need to worry about estate planning? The thing about that is that I have clients who come and go, oh, I don't have anything. I don't need a will. I don't need anybody to take care of my finances. You know, I don't have very much. What difference does it make? Well, we're talking about here your life and your property and what happens to you if you become incapacitated in any way, if you aren't able to make your medical decisions, if you can't go to the bank and write checks and cash checks and transfer assets and liquidate assets or sell your house. And ultimately, who gets everything when you die? You can leave a real mess for yourself, whether you're rich or poor. These core 4 documents are really important for everybody to have. And so this is from old to young. There's never too early a time, except under 18 or 21, depending upon your state laws for age majority. But there's never too young an age. There's never too old an age to get things in order. So the first big document is a will. Last will and testament. Wills are governed by state law, so every state has their own way of having a will set up to be legally official. And in a will document, what that's really all about is to say who gets what and when and who's in charge of things. So when there's a will, you have written instructions to your family members to what happens and who's in charge of things. Typically speaking, if you don't have a will and something has to go through the probate court process, the law in each state writes a will for you. There's a statute in Ohio, it's called the statute of descent and distribution. It's sort of a family tree that says who gets what if you haven't said so. There's problems sometimes with that. You know, each state is a little bit different. So if you're married and you expect your spouse to get everything, in some states, assets would be split between your spouse and children, and that may not be what you want. If you want to disinherit one of your children because of various issues, they're not really in touch with the family, or you gave them a large gift which causes them to not inherit when you die, it's shared by other family members, and you don't have a will that explains all of that, then this statute of descent and distribution would say no, all 3 of your children share equally. So if you don't put it in a last will and testament, then there's nobody that's going to know how you really want things to be distributed, and things might not go the way you want. So it's really important to have that last will and testament, which says who gets what, and also names who the one is that's going to be handling things in your estate. So that is typically called the executor. Some states call it a personal representative. There's different terms, but it all means the same thing. The person that you're putting in charge of handling your final affairs. Pay your final bills, clean out your house, cancel your magazine subscriptions, if anybody has those anymore. Seems like everything's online. But make sure everything's wrapped up, liquidate assets, sell your house, pay your taxes, and make sure everything ultimately gets distributed to the proper beneficiaries that the will says. Not what the law says, but who you want to get those assets. Very rarely do I have somebody who dies without a will, but it's so much more complicated to handle all of these processes that have to be done when somebody dies. If you're trying to sell a house and there's no will that gives you gives the executor the authority to sell the house, you have to go through, at least in Ohio where I practice, a land sale proceeding. And it's a complaint to sell the real estate. The court has to oversee the whole thing. It has to sell for a minimum amount. It's kind of like having it go through foreclosure and having a sheriff's sale. It's a whole lot more complicated. Everything is more complicated when you die if there's assets that have to go through probate. Now, something about the will. It's probably the most legal of documents that you're going to ever sign during your lifetime. And it's really, really important. But the will only controls what goes through probate. So probate is a court process when you die, and it's necessary if you have any assets in your sole name alone. Bank accounts or investment accounts or your house, if it's in only your name, the financial institutions, they don't know where it's supposed to go. So that's really the point of then the probate process. You file the will with the probate court, the executor is appointed, and then the executor has to inventory these solely owned assets, present that to the court. The court will make sure everything is administered and the bills are paid and everything's handled correctly until you distribute them assets according to what the will says, and then you have to file a final accounting. We're going to talk later in this presentation about probate avoidance. So a lot of times people would rather avoid having to go to court at all, and I concur with that. It's time consuming, it's costly, it's a lot of paperwork, and it's public record. That might be the one thing that people don't like or like the least, is that it's anybody can run down to court, pull your file, see what your will says, and who gets everything and how much your funeral costs. So there's a lot of reasons to avoid probate, but if you need a will because you forgot to title one of your assets the way we're going to talk about, it's really important to have that will so it smoothly goes through the probate process. And the other reason to have a will is, what if the way that you die is that you're crossing a busy street and a truck runs you over, backs up a couple times to make sure you're dead, and then drives away? Well, your family might want to sue that truck driver. So that's a wrongful death action, which has to be brought in probate court. So you need a will to file to name the executor to bring the action, and then the will says who gets what when your family, the executor gets the proceeds from that lawsuit. So a will is really important. You might not ever use it because you avoid probate and you die peacefully in your bed one night, but it's really important to have if you really do need it. So that's number one. So while the will handles your finances and what's going on with your money after you die through your executor, if you are using that, during your lifetime, there's a completely different document that is in charge of naming somebody to handle your financial affairs, which is the durable financial power of attorney. So this is a document you're putting in place so that if you can't run to the bank during your lifetime, if you can't sell your house, you can't sign papers, you can't get out of the house to take care of something. It could be also you're incompetent. You're naming a person to do all of those things for you. And this is a big, important power that you're giving somebody. You got to trust the person that you name 125%. If you give them all of this authority, then you're allowing them to go to a bank account, cash a check out of your account to themselves potentially, and take your money or invest your savings and invest your assets or deal with your financial investments in such a way that you don't necessarily like, but you've given that authority to them. So you have to be really careful who you name. And you should name not just one person, but successors, like first your spouse, and then your children, maybe oldest to youngest, or the one who lives closest to you to the one who lives farthest away from you. So you need to have somebody and successors. It's important what powers are allowed in that document. You can make it effective immediately. You can also make it effective only upon your incapacity. So where the one immediately effective is sort of a general durable power of attorney, the one that's effective only upon your incapacity is called a springing power of attorney. It springs into effect when you are no longer competent to handle your financial affairs. And usually it requires either a letter from one or two doctors to the person named as power of attorney so that they can then have the authority, because you're now incompetent, and prove it with these doctor's letters that you can take over, the power of attorney can take over and handle things for you. So, and durable, the name durable in the title means that it's effective even when you do become incapacitated. Most of today, they almost all are the forms that you see, but in the bad old days, powers of attorney were only effective and able to be used when you, the person naming somebody, was effective and able to make decisions. So they were not durable. They didn't last if that person became incompetent. But this became a big problem in a case. A woman came in for Medicaid eligibility for her husband, who was in a nursing home, and see, he was completely incompetent. So I asked, did he give you a power of attorney? And she said, yes, of course. And she proudly brought it out. And it was done when he shipped off to World War II. It was not durable. When now that he was incompetent, she was not able to use it to handle any of his affairs. So powers of attorney are important to look at from time to time. The laws change. The banks and other financial institutions change their requirements. It's the most often updated document that I do because of the law changes. One of the more recent changes is most financial institutions decided they didn't want to have any liability if they rely in good faith on the power of attorney that's presented. So mom gave her son a power of attorney, and he goes to the bank and says, Mom told me to withdraw $10,000 in a check payable to me. So the bank looks at the power of attorney, goes, yeah, ma'am, it looks valid. She signed it. It's effective immediately. Okay, we're going to rely on this. And they cut the check to the son for $10,000. And mom says, wait a minute, I didn't mean that. Son, why did you do that? And tries to go after the bank. Most banks now require an indemnity clause in there so that they can't be sued if they relied in good faith on that power of attorney. And the mom has to take it up then with her son. So indemnity clauses have become important, and many financial institutions have these rules that say a financial power of attorney is only good for 3 years or 5 years or 7 years, or other kinds of limitations. And you need to keep up with all of those rules and regulations, and also should probably read the statutory allowable, the rules for financial powers of attorney in your state, because some of the statutory rules are at odds with what some of the financial institutions are requiring. It makes it hard sometimes to get some institutions to accept it. But you need to have one. It's so important. Now, if you don't have a durable financial power of attorney, so nobody can handle your financial affairs if you are incapacitated, then typically that means somebody in the family has to go to the county probate court and become your guardian. There's a couple kinds of guardians. For this purpose, it would be guardian of the estate or the money. Some states call them conservators. In Ohio, it's a guardian that would be appointed to handle the financial affairs. But then you're kind of in probate during your lifetime. There has to be an inventory of the assets that are going to be under the guardianship. There has to be doctor's letters declaring your incompetency. There has to be accountings done, and the court's watching over everything. So it's just a lot more hassle to go through that whole guardianship in court rather than just having a document that allows your child or your spouse to take care of things for you on it very easily. So, okay. So we talked about financial, that durable financial power of attorney. How about medical decisions? There is also in most states something like a healthcare power of attorney. And if you have a healthcare power of attorney, you name somebody to make your medical decisions if you can't do so. Most state laws say that it's not like durable and effective immediately like the financial power of attorney is, so that you can just grab the paper, go to the bank and take care of something, whether or not the person who named you is competent or not competent. Under the healthcare power of attorney, most states say it's only when that person is unable to make their medical decisions that the healthcare power of attorney named has the right to then step in and talk to the doctors and make those medical decisions for the person. Usually a companion document, sometimes it's one document, sometimes it's a companion document, which is a living will, which I'll talk to you about in a minute, but they usually work together. And again, if you don't have a healthcare power of attorney and you're not competent to make your medical decisions, the only way that somebody can be named to make your medical decisions is, again, going into probate court and having someone named as the guardian of the person. Person means healthcare decision making, and estate means dealing with the money. Somebody can be in court and be guardian of the person only, of the estate only, or both. So again, you're back in probate even while you're alive, and we're trying to avoid probate in most cases. So it's much better to have the healthcare power of attorney named and in charge of things, rather than the court appointing somebody that goes to apply and, you know, helping them make medical decisions for you. Again, living will, that's what I said. That's the fourth document, is this living will declaration. So it works with the healthcare power. You need both documents if they're not in one, you know, one document together in your state. The healthcare power of attorney allows someone to make medical decisions, anything from very simple decisions to middle of the road stuff, all the way to end of life choices. And the living will really deals with the end of life choices. In Ohio, the definition for end of life is if two doctors determine that you are terminal or you're brain dead, there's nothing that they can do to make you better. And the purpose of the living will is to help you put in writing your end of life decisions that you want to have taken, you want to be honored if you can't express them anymore. So typically you're going to be saying whether it's kind of, I call the pull the plug document. It's whether or not you want to be hooked up to machines to keep you going, even if you know, there's really no hope for you surviving any kind of, or having any kind of real actual life after, you know, because of this illness. So you name people to be notified by the doctors if you're in this position, usually the same people as you have as your healthcare power of attorney. So if you're in this situation, two doctors agree, they come and tell the family members who are named, hey, we think that it's time to make these decisions, and does she want to be hooked up to ventilators or, you know, anything to keep her body going. And if the person has signed this document saying, I do not wish to be hooked up to those machines, just keep me comfortable and let me go, then that will guide the healthcare power of attorney in making that final decision about what to do, you know, what the doctors should be doing at that point. So it's really an important document, and it's one that most families, I recommend they have a conversation about what's enough, what's too much. There are some states that have checklists. I want this, but I don't want that, you know, so you can have a discussion of going through those checklists. Ohio doesn't happen to have that, but there are also forms out there that can be used for a discussion with the family as to what would you allow and what would you not allow, so that there's no guilt. There's an informed decision being made at that time to either hook the person up or keep them alive for some period of time just in case, or to stop all the treatment at this point. And the decision can be changed. The living will is guidance. If the family feels like, no, let's just wait another week, that's okay. It's not like what people are afraid of, where the doctors are wheeling someone down the hall and says, oh, wait, this one's got a living will. Slow down, let her die. We need her for organ donation. It's not like that at all. So that's a fear that a lot of people have that is just not true. So I kind of already talked about all of this. So when we're talking about estate planning documents, the basics, to be able to have somebody's assets taken care of, their health documents taken care of, their wishes as to who gets what and when and how and who's in charge of things during life and death. These are the core 4 documents: last will and testament, durable financial power of attorney, healthcare power of attorney, and a living will declaration. That's the scope of what we're talking about today, the basics that everybody's got to have no matter what.